Good afternoon. Welcome to the meeting of the Regulation Subcommittee of the California Paraprofessional Program Working Group. We'll take roll. Hardston?
Here.
Hardston?
Here.
Okay. Krickmeyer?
Here.
Zaruch?
Here.
Okay, great. Everybody is here.
Shall we take public comment?
Yeah.
Let's see. I see a number of people among the attendees. If anyone would like to make a comment, please raise your hand using that function in Zoom. A lot of people here today. I don't see any raised hands.
Okay.
So
why don't I share my screen? So we are going to, as I think I indicated, we need to adjust our schedule because I accidentally did not send something to Amos that I meant to. Apologies again for that. So we are going to take up the issue of informed consent and the written agreement at the next meeting, which is Friday, June 11th, to give Amos time to propose any additional revisions and also to consider the revisions that were provided by Fariba and Kim. And thank you for those. So can everyone see this screen right now? Okay. So what I suggest that we do today, because we have one other rule, issues related to a rule that we have classified as being a little harder, although I'm not sure it's as hard as the informed consent and written agreement one. But Rule 5.4, there's some feedback that we got from members of the working group, as well as from Professor Moore on this rule. It's a very important rule. So I thought we should probably try to wrestle with this now and not reserve it for our final meeting when we're going to take up the informed consent and written agreement rule. We should probably just make sure at the top of the hour that we stop and see where we are. Hopefully we might be able to get through it in less than an hour. I had allotted 45 minutes for this discussion, so we'll see how that goes. And then move on to the last outstanding issue that we have with Rule 1.5, which is a fee cap on contingency fees. And Leah had provided some materials to help guide that discussion. And then I know Kim needs to leave at 2:25, so I set 3 other rules where I think we can probably dispatch with these issues rather quickly, but we'll see how that goes. And that's Rule 1.13, which we have struck because this working group has decided that paraprofessionals should not represent organizations, but there are some other issues involved with that, especially when we consider the fact that the recommendation is also that paraprofessionals should be allowed to practice in the same firm with lawyers who may be representing organizations. And then similar issue with Rule 115, which we can talk about. And then there's one particular provision in Rule 3.3 counter toward the tribunal that we should probably revisit now that the full working group has a general recommendation for full court representation. So moving to back to Rule 5.4, as you'll recall, Steve Fleshman had expressed, I think there's 2 issues that I got from Steve's comments. One is that he feels that if lawyers and paraprofessionals are practicing in the same firm, paraprofessionals should only be employees of the firm and not be owners. That was one comment that he made. And then he and I think some others may have voiced some support for this notion, which is he found it undesirable that paraprofessionals could share fees for legal services that they're not permitted to provide within the scope of their licensure. And this is related, I think, a bit to our prior discussion of fee sharing among paraprofessionals and or lawyers who are not in the same firms. So I think we need to probably focus on those 2 issues and come to consensus on those. And then I would like to take up Professor Moore's comments with regard to paragraphs E and F. So I'm going to switch over to the draft of the rule. Okay, can you see this 5.4?
Yeah.
Okay. All right. So his first comment, I think, is a general comment that he doesn't believe that they should be, paraprofessionals should be permitted to have an ownership stake in a law firm in which lawyers also have an ownership stake. And so I just wanted to open that discussion and see if any of the subcommittee members have comments on that.
Greg, I'm sorry, could you zoom in just a little bit on your screen?
Is that better?
Yeah, even maybe a little bit more for me. That's fine. Thank you.
So again, I can, while we're formulating our thoughts on this, just to run through again what the function, this is a multifunctional rule. The paragraph A establishes that paraprofessionals should not share legal fees directly with anyone who's not a lawyer or a licensed paraprofessional, except that, and these are essentially track the same exceptions that are in the lawyer rule, including A6, which is the newly added subdivision that the court approved a few months ago that was recommended by the ATILS Commission, allowing them to share a legal fees that's not court awarded, but arises from a settlement or resolution of a matter with a nonprofit that retained, recommended, or facilitated their employment. So A really tracks the lawyer rule. Paragraph B, again, also tracks the lawyer rule, except for obviously conforming changes. Paraprofessionals shall not form a partnership with an individual who is not a lawyer or licensed paraprofessional if the activities of that organization consist of the practice of law. C also tracks the lawyer rule closely with conforming changes. You're not permitted to, shall not permit a person who recommends or employs or pays a licensed paraprofessional to render services to direct or regulate their independent professional judgment or interfere with the paraprofessional client relationship in rendering legal services. D is similar to B, except that it is really focused on professional corporations or other organizations that are authorized to practice law for profit. Again, this largely tracks the lawyer rule. You cannot, they cannot practice in this type of organization if an individual who is not a lawyer or licensed paraprofessional owns an interest in it, except that it allows for a fiduciary representative, a lawyer's estate, to own it for a reasonable period of time while they're settling the estate. Or if an individual who is not a lawyer or licensed paraprofessional is a director or officer of the corporation or occupies a position of similar responsibility, or if a non-lawyer or non-paraprofessional has the right or authority to direct or control their independent professional judgment. So that essentially is very similar, but it does suggest that it allows licensed paraprofessionals and lawyers to combine in these types of combinations. What we did here, and ignore for a second because I deleted E for now, but E and F were taken directly from the Washington rule. And Washington has a rule. What they did with their 5.4 was they essentially did the only conforming changes. So replacing the word lawyer with paraprofessional, I'm sorry, triple LP in that case. And then they added a rule 5.9 that essentially begins with, notwithstanding rule 5.4, a paraprofessional can do the following. And they can share fees with a lawyer who's in the same firm. They can form a partnership where the activities consist of the practice of law. They could practice in the form of a professional corporation. I'm actually just going to reject deletion so you can see this. And so I added this based on the regulation subcommittee's decision to allow paraprofessionals. It was a general decision to allow paraprofessionals and lawyers to combine, and just as for discussion purposes, took their rule and then grafted it into 5.4 here. So that's a big windup. I just want to see if anyone has any feedback to begin with on Steve Fleshman's comment. First, that paraprofessionals should only be employees when they're combined in a law firm with lawyers. And second, that they should not be sharing legal fees if they're for services that they're not licensed to provide.
So I'm happy to start. If you recall, was in favor of what I think we proposed, or at least for discussion at the full working group, which is allow paraprofessionals and lawyers to combine in firms with joint ownership, with the limitation that it needs to be a minority ownership. And I think we did look at other states and we considered other options, and there were policy reasons behind wanting them to be able to build firms that actually might have more paraprofessionals and lawyers. It's not necessarily joining a big existing law practice. But a big red flag came up at the full working group meeting with the concern raised about sharing fees on matters that were outside the license practice area. Because I think, practically speaking, I'm not sure how we would limit that if there's an ownership interest in the firm. And I'm not sure why practically that we would want to. So I think there's sort of the initial, I think it really raises a big hurdle if we're going to try to limit fee sharing within the same firm to an owner, because that's not really how ownership works in the real world. You're a 10% owner, you get 10% of the profits, and it's not, there's not sort of an accounting within the firm for which matter is which. So that raises real concerns for me on a practical level. And I think the comment was also keep it simple for the rollout and leave 5.4 to the other committee or working group, that closing the justice gap. And I think we should seriously consider that. So my position is I like the idea of joint ownership with the limit of minority ownership only, but I don't think it's really workable if we have this concern or objection about sharing fees in matters outside the practice area, or we really have to think about how we would accomplish that.
I fail to understand the concern with regards to sharing fees in the area that the licensed professional is not licensed. As long as they don't do the work, what's wrong with sharing fees of the business?
And I have this, I'm the same as Fariba. I mean, I know we have corporations that have, we usually have, I completely agree with Amos that they should be the majority, attorney in majority.
I agree with that too.
And they should be a minority. And we have lots of firms under our corporations code where you have the same thing with multiple different types of licensees joining together. And I've never seen any law that limits them as to how they can divide up their, their earnings. And so I don't have the same concerns. I'm not sure what those concerns would be.
Mm-hmm.
So I think, so it sounds like we're all on the same page, which means this might go quick, but I want to play devil's advocate for a bit, because I think there are legitimate concerns, and it's really the whole fundamental purpose of 5.4 that is being considered by the other working group about potentially expanding it. So right now, lawyers can't share fees with non-lawyers, and it really has to do with independent judgment concerns. So the idea is you don't want non-lawyers making decisions about how lawyers represent clients. And it's sort of fundamental in our current rules, I think, in our current ethical rules. So I'll let our ethical experts speak to this a bit more, but the idea of lawyers sharing fees with non-lawyers, and here, although it'd be a licensed paraprofessional, it is a licensed paraprofessional that is not authorized to practice in, I think the example given was you have an immigration law firm and that has a paraprofessional that, they're not doing immigration work, but they're doing something else, but they're sharing in the fees of the practice of the immigration. And I think that raises all sorts of red flags from people who are familiar with the ethical rules that, don't allow fee sharing currently and the current, so I heard, I think we're all in agreement, but I heard pretty strong opinions, I think, on this issue from several members of the working group at the full working group meeting.
But Can I just ask a question? This would just be literally a corporation with attorneys and whatever the paraprofessional is going to be called, right? It would not allow any lay people involved in it, correct?
Correct. That would still violate the rule.
Okay, good. Yeah,
And-
I wouldn't want lay people, but yeah.
And the prohibition against the paraprofessional having some role in the strategical direction of the case, shared decision-making with regards to a case that an attorney is handling, that I agree with. I still don't understand maybe I'm sorry, I'm not recalling what red flags are there. If we limit the paraprofessional to not get involved in strategy and not be able to direct the attorney's work and not do work that they're not licensed for, what is the big concern with allowing them to share in the profits of the business that they're part owner up to 49%? Yeah. Am I missing something here? I'm so sorry.
No. I think that you've really struck on, I think, the main point here, which is you have you as a subcommittee have embedded within this rule that will allow paraprofessionals and lawyers other guardrails. One being that their ownership stake has to be a minority ownership stake, because again, 5.4, the thing that unifies all the different provisions of 5.4 is these are all safeguards to protect a lawyer's independent professional judgment from outside influence. And so to the extent that paraprofessionals have a minority stake, they don't have direct supervisory authority over any lawyers in the firm. They are not allowed to direct or regulate a lawyer's independent professional judgment. Those are safeguards, I think, that should, at least in some people's mind, address some of the concerns that normally you would have when non-lawyers are sharing legal fees with lawyers. Because the main concern with that, and we hear a lot more of this in Closing the Justice Gap group, is when you get corporations or some other entities whose main sole focus is profit generation and lawyers are working for them, then it starts to interfere with the attorney-client relationship and the attorney's independent professional judgment on how to conduct a litigation. But it would seem to me, with these safeguards that you've built into this rule, that would mitigate. I can't imagine with these safeguards in place that you would have a paraprofessional that holds so much sway in a law firm that it would somehow endanger the independent professional judgment of the lawyers in the firm.
I'm having a little bit of a hard time reconciling what I think was a pretty conservative position that the group took on, I think it's 1.5.1 fee divisions, and then this position. So maybe I'm not understanding the real distinction, like between, if you're operating in different firms, we've adopted the ABA rule, which is pretty severe. And then if you're in the same firm, though, the group is talking about a much more liberal approach. And it would be helpful just for me to understand what is the distinction between the settings, the same firm versus different firms, that might justify those different positions. Or maybe they're not that different and I don't understand them. But it does seem like 1.5.1, we're very conservative. Here, we're talking about something more loose.
For me, it's what you just said, same firm, different firm. I mean, they're partners in one firm, one business. It's the profit's a product of joint effort, right? So, and I just mean that not in terms of joint effort on one case, but just in general. So they should be able to share in the profit of the business. When it's different firms, I mean, to me, it's comparing apples and oranges, just in my opinion. I think I don't think we are doing anything wrong by having more conservative rules or strict rules when we're talking about different firms for fee sharing than in this scenario. Totally different in my view.
I also think we want to encourage different business models for this profession and allow creativity in who gets together and how. And personally, I think the more paraprofessionals and lawyers are working together, the better. Not necessarily true, but I think allowing ownership is a way to allow this to be a very profitable profession that you don't necessarily get as an employee. So I'm open to liberalizing it in the context of ownership of a business.
I certainly don't want to fight against consensus, which seems to be breaking out suddenly in this group. So
I do think this is controversial though, and we'll have a lot of
will.
explaining to do because again, I did hear both with respect to let's leave 5.4 alone. That's the other committee other working group working on it, and it's complicated and controversial, but also the independent judgment issue that Greg mentions is, if one of the bosses, whether it's 10% or 49%, they're still the boss, they're still the owner. And there might be some guardrails that we're putting in, but the bottom line is that, the employees who could be attorneys, paralegals, paraprofessionals, staff, technically in one way or another report solid line or dotted line to the owners. So, I think there is a real concern there, but I think, I favor allowing the fee sharing with the limitations.
And Greg or Leah, sorry, can
Go
you
ahead.
just, the difference between the 1.5.1 where we were more stringent, it looks like, I just scrolled up, but I might not have the most recent version, is that there's more consent, right? Under the 1.5, if they're in different, they're in a different firm.
So
that
there
right?
is a consent requirement to referral fees, but I think what Leah is talking about is we are not allowing paraprofessionals, or a recommendation is not allowing paraprofessionals to do a referral fee outside of their practice area. So if a family law paraprofessional gets an immigration case and refers it to an immigration attorney, they're not allowed to collect a pure referral fee. Is that what you're referring to, Leah?
Yeah, that like if a family law and immigration, if paraprofessionals and lawyers were in the same firm that did both family law and immigration, then under what we're talking about with 5.4, they could share in the profits, right? So they couldn't share if they're in separate firms, but if they're in one firm that they co-own, they can share in the profit. So for me, I'm just having a little bit of cognitive disconnect of why it would be one way in one situation and another in another. But like Greg said, if you guys all agree, and I don't think it's the wrong result per se, it's just I'm trying to understand the scheme.
I can actually explain that from my perspective as, non-attorney and not in, living in that world. When I look at the difference between that, giving a referral fee to refer me to somewhere else has a lot more capability, at least from my experience, in fraudulent activity and doing things for certain reasons versus just all being in one firm, and you have an individual that comes to you and you're sharing in those profits. Obviously, you want to keep that individual within your own law firm, and you're doing it to keep the business, as to where if it's in a different one, there's more possibility, in my opinion, I could be totally wrong, with some type of fraudulent activity and doing things for the wrong reasons.
I also want to raise, although I don't have a solution, I think there still is a tricky problem that I don't think a lot of established firms are going to be, having paraprofessionals with significant ownership stakes. That's not my concern. My focus is paraprofessionals starting their own businesses and wanting to partner with lawyers. But again, I think the minority ownership is a significant limitation, because if you have 3 or 5 paraprofessionals getting together, they can be co-owners, equally co-owners. But once they have a partner that is an attorney, they have to have a minority stake. So again, if there's multiple, there's ways around that. But I still think there's something a little bit tricky, right? If the model is you have a number of paraprofessionals getting together, and I don't know if they can have a lawyer as a lawyer as an employee, because I don't know if they're allowed to supervise. So we'll have to think through, if you have a paraprofessional firm with only paraprofessional owners, what are they capable of doing? Or maybe it just needs to be an external relationship with an attorney.
And as you can see on the screen, I am actually suggesting a change to what's now F to account a bit for that. And if they were to try to hire a lawyer rather than bringing in a lawyer as a owner. So it's now changed to that licensed paraprofessional shall not practice in a law firm with a lawyer unless or if, it depends on how we want to phrase this. This gets into Professor Moore's comments, but unless they comply with all these things. So it's not, the way it was written in Washington State is jointly owned. I think practice with a lawyer really captures what you're talking about, Amos.
And I'm reading this now, but the idea is it would be allowed, it would just have some guardrails. So
Right.
To preserve the lawyer's independent judgment, right?
Yeah. Well, go ahead, Kim.
I was just going to say, is there any concern on the flip side of that too, though? I mean, because there could be an attorney that's trying to tell a paraprofessional to work outside of their scope or to do things like that. There's kind of the reverse of that sometimes too in these corporations.
Right, and that actually is covered by a different rule.
Okay.
So that would be covered by Rule 5.2, a subordinate paraprofessional, and that it's similar to the ethical obligations of an associate in a law firm, where they have a supervisory or managerial lawyer telling them to do something that they know is unethical, and they need to comply with that rule in order to stay out of trouble. And so we have a similar rule for paraprofessionals as well.
I see it. Okay.
What is the implication of 2, F, I guess 2, no supervisory authority? So let's say you've got 3 paraprofessionals, because I feel like this would be the smart business model. You've got 3, they're doing family law, they want to hire or bring on 1 attorney, right? And then we say, well, you can't supervise them. So what does that mean? Like, this attorney doesn't show up. The attorney, I don't know, things that you have to supervise people for, uses the internet for non-work related things, is rude to the janitorial staff, all these different things. What does it really practically mean? Like, you've hired an employee, but you can't supervise them. Are we setting these folks up for problems?
Are you saying in a joint ownership situation where there's a paraprofessional and an attorney own the firm and they hire a subordinate attorney?
No, well, I'm talking right now, let's just say you have 3 paraprofessionals, they own the firm, because they don't want to give ownership to just one attorney. They have to give him 51% ownership under this rule. So they don't want to do that. They want to hire somebody. But then we're saying you can't exercise any supervisory authority. So you, just as someone that's managed staff, right? Because that's kind of a nightmare. Like, you have an employee, but nobody can supervise that employee.
I wasn't aware. Sorry.
I think we're saying that they can't, if it's a firm of 3 paraprofessionals who have 100% ownership stake between the 3 of them, they can't hire a lawyer.
That's right. That's what I thought.
They cannot hire a lawyer as an employee.
And that's the concern I raised too, because I agree, Leah, that business model seems like one that would make sense, but I think it's not being allowed here.
Well, but I'm confused by your edits to F. What do they do?
The edits to F are essentially capturing that a licensed paraprofessional and a lawyer cannot practice in the same firm unless they comply with these guardrails. And one of the guardrails is the lawyers have to own 50% or more. I'm sorry, 50%, 51% of the firm. The paraprofessionals have to have a minority stake in the firm. So if they're practicing together, then it has to be a majority owned, lawyer owned firm.
Right. Can I raise one additional question following up on Kim's question, which is if a paraprofessional is at a firm with lawyers, whether ownership or not ownership capacity, and they're asked to do something outside of their limited license under the supervision of an attorney, is it possible they would be allowed to do that acting as a paralegal as opposed to acting as a paraprofessional? Or does that get too tricky?
If they're acting as a paralegal, then by definition, they're not engaged in the practice of law.
Well, that's why I asked, because I just think we might want to contemplate that as a possibility, that in a combined environment, that they may be tasked with doing things that are not the practice of law, and we may need to anticipate that.
So this is 5.2 that I was referring to, responsibilities of, in this case, subordinate licensed paraprofessional. And this is essentially the rule that is imposed on subordinate attorneys, that they have to comply with these rules. And we don't have the State Bar Act because they're not incorporated yet in the State Bar Act, notwithstanding that the paraprofessional acts at the direction of a lawyer, another licensed paraprofessional, or other person. So it's essentially saying you don't get away with violating these rules just because you're doing it under the direction of a lawyer. And the B essentially does provide a safe harbor for lawyers, and in this case paraprofessionals, that they do not violate the rules if the licensed paraprofessional acts in accordance with a supervisory lawyer or supervisory licensed paraprofessional's reasonable resolution of an arguable question of professional duty. So on close questions, and it really puts the onus on the subordinate to raise the issue and allow their supervisory lawyer or supervisory paraprofessional to come up with a reasonable resolution. And if it turns out in the end that they were wrong in their determination on that close ethical question, the subordinate attorney, or in this case, subordinate paraprofessional, is not going to get disciplined. The supervisory attorney maybe, or supervisory paraprofessional maybe, but not them. So
I'm comfortable with 5.2. I guess my question could be better framed as this. Do we also want to have either a rule or a comment that contemplates a licensed paraprofessional acting in a, under the supervision of attorney beyond their license? So, beyond their license isn't the right, in a paralegal, non-practicing law capacity.
Can you explain that a little bit more? Because I'm not quite understanding.
Okay, so we have a majority immigration law firm that also has some paraprofessionals. Doesn't matter, I think, if they're employees or owners, if they're doing, let's say, family law. Lawyer says, we are crazy busy on our immigration cases. We need all hands on deck. We need you to help, with these immigration forms and go down to court. And you don't have to be a lawyer to do it. And I'm a lawyer and I'm supervising you. So act as my paralegal. Do we want to have some sort of safe harbor or some sort of language that says, you're in that instance, you are allowed to do that, but you're not acting as a licensed paraprofessional. You're acting as a paralegal under the supervision of an attorney, subject to all the rules that apply in that situation.
So let me jump in and say maybe this is a much more global issue, and maybe it's something for a comment to 5.5.
Mm-hmm. Let's just roll to 5.5, which is the UPL rule.
I think a comment could be helpful. My other observation is I think the law already contemplates that hypothetical. So these rules would prohibit the paraprofessional from performing legal services outside the scope of what they're entitled to do. A lawyer can't assist a non-lawyer engaging in the unauthorized practice of law, which the licensed paraprofessional would be doing if they're providing legal services outside the area in which they're licensed to provide legal services. However, a lawyer can have non-lawyer subordinates engage in work of a preparatory nature so long as the work becomes that of the attorney when it reaches its final work product. And I think the law is pretty clear on that, but notwithstanding that, I understand Amos's concern because this is a new area of law, so or new licensed professionals, maybe a comment just describing that scenario or those authorities could be helpful. But I don't think a rule is necessary. A long way of saying I don't think a rule is necessary to address that because I think the existing rules and law already contemplates that.
What about the question of whether it needs to be clear to the client what if they're operating, in their individual capacity as a licensed paraprofessional, or if they're acting, as a non-attorney subordinate to a licensed attorney? Because again, in my situation, let's say a problem happens, there's a complaint by the client. This licensed paraprofessional was assisting me and messed up my immigration case. The first reaction is going to be, wow, that's outside of the practice area. There's a UPL issue. But in fact, it might be, oh no, we have an immigration practice at our firm and, an attorney was supervising. So again, for me, it seems like it might need to be clear what capacity they're working in to the
So
client.
even in that example, I would hope the immigration lawyer contracts with the client to provide the immigration legal services. And thus the client is clear as to which assets of the firm are doing which legal services for the client. I mean, that's my own view. I'm not trying to be naive, but I think existing laws and rules would hopefully get at much of that.
I think we should consider when we get to the comments, whether or not we need to explain. It's related in some ways to Kevin's comment here, which is the paraprofessionals really need to be educated and trained to understand precisely when they're acting within the bounds of their licensure and when they're acting outside of the bounds of the licensure. Not only that, their supervising lawyers need to understand this too. And to the extent that they're asking them to engage in the practice of law, they are putting themselves at risk and their license at risk by allowing them, by essentially assisting them in the UPL. So there needs to be education probably on both sides. And I think we probably captured this right now. I think when we get to comments, we can try to figure out where that fits best. I think that's a good point. The other thing is that it really kind of begs the question of whether or not we need a Rule 5.7 for law-related services and ensuring that even when a paraprofessional is providing law-related services, that they are complying with their ethical obligations. But that's something that's also being considered by the Closing the Justice Gap vis-a-vis lawyers. So it may be something that we reserve for now until they address that issue.
So could you recap, where did we end up on this issue?
Yeah, we got a bit off track because what we're trying to do is get, although I think that was a good comment, we're trying to come to resolution on 5.4, and it seems like we're there. It seems like this group, one, agrees that we should not have a constraint that paraprofessionals can only practice in law firms with lawyers as employees, that they should have an ownership stake with the guardrails that we have in place here. And that I think we bring that back to the group, and those who are opposed to that or have some concerns about paraprofessionals sharing legal fees from matters that they're not licensed to provide services for, that they need to, because I feel like the conversation in the full working group was rather quick and not as well developed. And I think some of the questions you had, Fariba, as to what exactly is the purpose of that kind of a restriction, that really gets to the heart of 5.4 for a lot of people, actually. And allow them to voice that, and then we'll come to a consensus as a working group on where to go from here. The only other things that I wanted to address here is Professor Moore's comments, which
Before you move on, I'm so sorry. I also wanted to know where we ended up with regards to Amos's concern that a paraprofessional be sort of flexible and be able to jump back and forth between being a licensed paraprofessional in the area they're specializing in this firm versus being just a paralegal who's supervised by an attorney in doing a task. Are we
Yeah.
saying that licensed paraprofessionals should not be able to have that flexibility?
no, what we're
Okay.
saying is that the current rules actually already set up ethical strictures for those people that are switching hats. But what we need to do probably as a regulator, especially in the licensing process, is really educate paraprofessionals as to understanding what is the scope of their license, recognizing when they're acting as a licensed paraprofessional and when they're not, as well as the supervising lawyers, because they can get themselves in hot water from a disciplinary standpoint if in fact they're allowing paraprofessionals to practice outside of their licensure. But the current rules really already set up the standards here. I think what I tried to capture is just that Amos had brought this up as a potential comment, interpretive guidance under the current rules. And I also think it's something that we need to think about when we are talking about educating these licensed paraprofessionals in the licensing process, so they understand. But I don't think we need to change the rules right now from where they are to handle that situation.
Okay, got it. Thank you.
So again, just as a reminder, this blue text here, this is really the rule 5.9 from Washington State Paraprofessional Rules. The concern that Professor Moore had, and I actually haven't had a chance to really talk to him in depth about it, but I think I understand it, and maybe Randy and Andrew, you might have a better perspective on this. But I think his takeaway from the way this read was that it would allow lawyers to have a passive investment in a paraprofessional law firm, and whether or not we really want that. And the other issue was, and this is a very good point on his part, other states do this very often. They write the rules of professional conduct in this type of permissive language, which we have in California really eschewed as much as possible, because we are trying to establish minimum disciplinary standards. And so rather than providing like practice guidance, or we can do some of that in the comments, but and the more I considered it, the more I realized I'm not sure we need paragraph E at all. Because it's really telling paraprofessionals that they can share fees, they can form partnerships with lawyers. And that is already, I think it pretty much set forth in F. If you say they cannot practice in a law firm unless they comply with these guardrails, I think that's already clear. So E actually becomes more confusing. And if anything, I would think that this is best served as commentary to the rule. But I wanted to get everyone's feedback on that. That's one point. And then the other point, which I've tried to do here, is address his comment that it needs to be in prohibitory language, which is consistent with our rules of professional conduct. So rather than saying a licensed paraprofessional and a lawyer may jointly own a law firm, only if, I change it to a licensed paraprofessional shall not practice in a law firm with a lawyer if, we could do if or unless, it depends on how we want to do it. But if it's if a licensed paraprofessional directs or regulates, we'd have to change the verb agreement. Oh, no, that's fine. Any lawyer's professional judgment, and just change the way it's worded here. And then once we discuss that, I also want to talk about this provision right here, because I'm not sure this is necessary since we have supervisory rules that already handle this issue. But that's, I think, probably the best way to guide the discussion here is whether or not we really need paragraph E. As
So
a
one reason I think we might need E, although we might be able to revise E3, is the example we just discussed, which is an attorney working as an employee. I don't think is covered otherwise.
Well, and that's the question for the group. My understanding is that the group does not want attorneys to be employees unless lawyers have a majority stake.
But where is that? So I think that's right. But where is that
Well, that's
prohibition?
covered right here. So this covered right here. So they cannot practice in a firm with a lawyer if licensed paraprofessionals possess a majority ownership stake or interest or exercise controlling managerial authority in the firm.
I thought you were suggesting we don't need this rule. So I agree that's in
No.
here.
I'm sorry. I'm suggesting this part that I've now highlighted is unnecessary.
Oh, got it. I thought you were talking about the second.
Yeah.
Sorry.
Sorry about that. This
So-
is critical.
Right.
This is critical.
Right.
So my question is, do we need to specifically say that paraprofessionals cannot hire an attorney as employees? They can only be co-owners? Or does this say that, you think?
I think we can provide that as interpretive guidance in the comments.
Okay, okay. I think that would be helpful, just
Yeah.
clarify.
Okay, let me,
So can I ask Greg, if the first part of 5.4 prohibits lawyers and licensed paraprofessionals from sharing fees? Because
No.
that's the question, I think.
no, it doesn't. It says that a licensed paraprofessional or law firm shall not share fees directly or indirectly with I changed it, somebody put it in person at one point. Person actually includes non-individuals. So that's an interpreted word. So I changed it to an individual who is not a lawyer or a licensed paraprofessional. So it's essentially excluding sharing of fees with anyone who's not licensed by the state bar.
Okay, so I agree then. Probably a comment is necessary. It sounds like I'm more on the comment, too many comments, but again, because it is somewhat unusual and a break from tradition of attorneys sharing fees with non-attorneys, that it probably needs to be pretty explicit, at least in the comments, but it sounds like it is otherwise allowed and not prohibited.
Majority paraprofessional owned. Okay. Kim, do you have any feedback on this?
I'm struggling because I'm actually going back to Leah's earlier comment about the 3 paraprofessionals with 1 attorney, and basically we would be stopping that. And so I'm not prepared to talk about it right now. And Greg, maybe I can send you the section and you can kind of look at it. But with our licensees, we have this that happens a lot where you have, like the doctor who's he's at the top of the healing arts professions, right? And then you have them joining into a medical corporation, but he has to be 51%. It's in the corporations code. But then you can also have like a nursing corporation where a doctor can be a part of, and he's not a majority. The nurses have to have a majority, but they're still allowed to practice to some degree. So you'd have like a law firm, and then you'd have a law corporation, and then you'd have a paraprofessional corporation, which would allow to some degree what Leah's talking about, where they'd still be able to practice law, but they'd be part of this corporation, where it would kind of allow that type of agreement, but still we'd have to have safety, concerns around it, like we're doing here. But I just don't know if anybody else feels that that's important, that we should go into that to look at that. Does that make sense?
It
Like-
makes sense, yeah.
So in that example, Kim, where in a nursing corporation, a doctor can be were you saying a doctor can be a minority stakeholder, or a doctor can be hired as an employee?
They can be part of it, and they can also be, I believe they can also be an employee. It's been a long time since I've looked at that corporation's code, but it's 13400 at SEC. There's like a bunch of sections there. And we kind of have built, the way we do corporations amongst healing arts around that code section. So I don't know if it's worth looking into just to allow that type, or if we're just in any type of agreement where, you know, you have paraprofessionals and attorneys, it should just always be that the attorney has the majority, then it's not worth us looking at that. But it just did when Leah said that, I was like, yeah, you're right, that is, and I think Amos kind of mentioned that too. That is a great model where you'd have, you know, these one individuals and they'd have one attorney maybe that they could work with within their corporation, but there'd be no way to do that unless that one person was a 51% share owner. So.
Well, to me, it's an access to, I keep just having access to justice as a goal. I'm just wondering if we go with what we have and prohibit that, how are we impacting our objective of providing more access, right? So right now, if paraprofessionals want to engage an attorney, they have to refer out, and then they're under those rules. I'm just wondering if we expand that to say, oh no, you can hire an attorney and kind of come up with some rules around that. Is that going to provide more access? I'm just not seeing that. I think that's, I don't know what everybody else thinks. I want to be convinced that I'm wrong.
Yeah, you're right.
I just don't know if there's a need for that.
Yeah. That's what we heard right before, is that they all refer out. So yeah, I guess, yeah.
So under that scenario, you will run into objections from people saying, you know, paraprofessionals should not be supervising lawyers. And if they're a pure employee, there's no way that the paraprofessionals cannot interfere with the lawyer's independent professional judgment, because it's their boss. You know, they're going to do what their boss tells them to do, or at the risk of losing their job potentially. So that would probably be the concern from others.
Yeah.
Do you know, Kim, and I'm sorry to bombard you with questions, do you know if with regards to nursing corporations, whether they are allowed to supervise the doctor if they hire one?
They can't. No, there's arms around that where they can't tell them what to do, even though they're in that corporation.
So how do they get around what Leah was saying, the problem that Leah brought up, which regards to?
Yeah, you know, Fariba, I don't know. It's like I said, it's been a while since I've looked at it, so I'd have to go back and really look into those laws. It's been a bit.
So I think we may be creating a problem if we allow that, where one doesn't exist. And it's also, these are all subject to change. So once we roll out the pilot, we could re-examine this part of it maybe. I just think we shouldn't create a problem.
So just in response to your question, Greg, I'm okay actually with taking E out. I don't know that it adds anything now that you've kind of pointed that out. But I do think we should reverse the language to where it is actually, I would, rather than the if, I would do an unless and write it more like that. It just makes more sense to me, but that's my opinion.
You're muted, Greg.
Sorry, I could see that. The reason I did if is this is the construct that they've used elsewhere in the rules.
Got it.
If, and so I was just trying to mirror
Okay.
that as well. Shall not, and this is except that. This is an exception, but so that's the reason I put it in this word. But yeah, unless it's, I'm not even sure if that's consistent throughout these rules. Randy, do you have any sense of that, if we only use shall not and if as a combination as opposed to shall not unless?
I don't know if it's consistent, but
yeah,
shall not, I know is the formulation. I know others prefer
definitely shall
must.
not. Yeah.
And then on 4, I actually do understand that addition in there. And it made sense to me when I was looking at it earlier when you sent this out.
Yeah, so just I could talk about 4 a little bit more, because I think you need to see 4. So 4 says they can't practice together if the licensed paraprofessional with managerial authority do not expressly undertake the responsibility of for the conduct of the licensed paraprofessional partners and owners. I actually think Rule 5.1 for paraprofessionals goes even further to say employees as well, paraprofessional employees, they have a responsibility for, to the same extent as managerial supervisory lawyers are responsible for the conduct of lawyers, subordinate lawyers under the lawyer rule 5.1. So the reason I think this is unnecessary is because I'll go up to 5.1. Went too far. Responsibilities of managerial or supervisory licensed paraprofessionals. This already sets forth those responsibilities. So I don't know if we need to reference and actually I think it's more confusing in some ways and potentially could lead to some weird interpretive, conflicting interpretive guidance from different sources. If we, in that rule, refer to the lawyer rule 5.1, when we already have a 5.1 for supervisory and managerial paraprofessionals and what they're supposed to do.
That makes sense to me.
Yeah, makes
Okay.
sense.
The only thing that's in E that's not in F this is a question, is what Amos raised, like this explicit statement that they can share fees. Right?
Yeah, and I think we can add that. So I think we add comments to clarify that paraprofessionals and lawyers. Yeah, and that's what I was suggesting up here is that actually we could take all of this, the concepts that are here, and put them into a comment. It can form a partnership where the activities consist of, and that's really clarifying what will become E, because this is written as a disciplinary standard, and then the comment says, with that standard in mind, these are the things you can do, and that's providing guidance, if that makes sense. So we would say they can share fees in the same firm. They can form a partnership. I love watching everyone has to type. Okay, share fees. Okay. But and we'll try to capture that. So it seems like we have an agreement that E should come out, and everyone seems to be fine with the formulation of F. And I think, and I will check in with Professor Moore to see whether or not, and we're removing 4. If he still thinks as written, it's suggesting that lawyers can have a passive investment. I don't think, and if so, I think we will have to circle back and figure out how we can foreclose that, because I assume that the regulation I shouldn't assume, the regulation subcommittee would not want lawyers to be able to passively invest in paraprofessional law firms.
I agree with that.
Okay. Okay, I will circle back with him then and just make sure that we've captured his concern and addressed it. All right. Wow, we did it in an hour. This is good. Okay.
Greg, I have a quick question. I think
Sure.
it'll be quick on 5.4A.
Yeah.
The introductory phrase, it says a paraprofessional or a law firm. Do we mean a paraprofessional firm, or do we mean a law firm as defined in the rules of professional conduct?
Well, we've defined it here too, under these rules. So if we go back up to the rule definitions, a firm or law firm means a licensed paraprofessional, licensed paraprofessionals, a lawyer or lawyers in a law partnership, professional corporation, licensed paraprofessional. No, that's a mistake here. Licensed paraprofessional acting as a sole proprietorship and authorized. So we've essentially defined that term for purposes of these rules as well. And this is,
Okay.
Andrew, this is one of those conforming changes that we're going to have to consider now for the lawyer rules. Not to the extent that we are now, assuming this we stand up this program and we adopt these rules, that lawyers are now going to be permitted to practice law with paraprofessionals in the same firm. So I think there's a number of rules where we're going to have to go back, lawyer rules, and make some conforming changes. This may be one of them.
Okay, thanks. I don't want to hold it up. That helps. Thank you.
Okay, so back to our work plan. We were going to move on. Oh, the fee cap issue, contingency fee caps. And Leah, do you want to kind of
Yeah.
guide us in this discussion? I'll go to 1.5, or do you want me to stop sharing and you can share?
Yeah, I just didn't pull it up. So I sent, I think, a couple meetings ago. Sorry, I'm having trouble getting to my documents.
I think I can pull it up too.
I sent a couple meetings ago some of the background material from the discussion that we had about fee caps that I thought was most relevant to the decision that you all will need to make about a fee cap for contingency fees. So hopefully you got that. And then what I did, which I'm struggling to pull up, but I think I've got it now, is to model some various options. I'm struggling to find this now.
I think what Greg attached, Leah,
Oh, did you, Greg? I didn't see what he attached.
your
Is it-
scenarios.
It's an Excel. It's a little Excel.
Yeah, I
sheet.
attached it to the email. I can pull.
Okay, here we go. I have also found it in
Sure.
my morass and slow. Okay, so basically, I simply, I kind of looked at all the different schedules. I'm going to try to make this bigger that courts have, and the courts, right? These are presumptive caps for awards. And they're all different, but there was some similarity when I really started looking at it. So I just mocked up for all of you like 3 scenarios with an award of $25,000 and some of the options. The first 2 really come from some of the patterns that I saw in looking at what the superior courts are doing. And then the scenario 3 is easy, right? Just picking a flat fee percentage. So you can kind of see what you get and what the bottom line percentage is for the overall award. And I used 25,000 because of our limited jurisdiction limit, but understanding that there could be an award greater than 25,000, but it's easy to change these numbers. So, I think we kind of have to come up with something and open for discussion. My own thought is scenarios 1 and 2 I prefer something less complicated. So I think we should do a flat amount personally.
I'm sorry, who was talking? I interrupted.
No, go ahead, Reba.
No, I just said when I read the private child support corrector statutes, I was really surprised that there's really no limit to what they can charge. It's set by themselves. The only limit was how much the child support obligor would have to later pay.
Right. And even
and so-
that was in relation to like the outstanding amount owed or
Right.
half of the total fee charged by the attorney, but there's no cap on what the total fee charged by the attorney.
Exactly. So I just, and that's a group of people who were really abusive and I think it's still a really, there are a lot of bad actors out there. But anyway, if they're not being restricted, I'm just wondering, what the rationale would be for us to restrict this group of people. Anyway.
So my view is we initially, I think, decided, and I don't know if it was an official vote, but I think we were in agreement to prohibit contingency fees entirely as a consumer protection. I think we then move to think there might be an access to justice issue specifically with respect to enforcement of judgments. So we could allow contingency fees specifically with respect to enforcement of judgments subject to a cap. If it doesn't have a cap, I think I would prefer we go back to the prohibition on contingency fees. As far as what a proposed cap is, I agree a flat percentage is the easiest. And I would actually be more liberal than this. I think, again, for me, it's a consumer protection. So the issue is it shouldn't be 50% or 75% or 99%, but something, a third, 33 and a third percent, which is normally where I think contingency fees are, unless you're at a trial or something like that, is just as a consumer protection, as a limitation, makes sense to me. So I would be, 25% is fine, 33 and a third percent is fine. But if there's no cap, I think I would vote to not allow contingency fees at all, which is what we initially decided. I think this was an exception.
And what issues of, what areas of law are we leaving out here?
It's just enforcement of judgments.
Just enforcement of judgments, so nothing
Yeah,
else.
so I think we originally said no contingency fees at all. And then we just decided to allow contingency fees subject to cap for enforcement of judgment proceedings.
And I remember when I first came in, I was opposed to capping the contingency fees, but then we talked about it, and if definitely not with a prohibition, but then once you explained that it was open, I was okay with capping it with something. But I agree with the scenario 1 and 2 just seems complicated, and yeah, a lot to it, especially when it's very limited. That was the other reason too, is it's very limited. So if we are going to cap them, I would agree that it should just be a flat fee like scenario number 3 is.
And I agree that there should be a cap. I totally agree. I wish they would change legislation to add the cap to the other groups. But I just want us not to pick a number arbitrarily. What are we basing, whatever rate we pick, what are we basing it on?
Well, that's why I gave you the data I have. I think we have data. There are fee caps, right? There are fee caps in different situations. There's MICRA, there's workers' comp, right? There's different fee caps, and I think the low end is this 9% that you see in workers' comp, but really it looks like in practical terms, you're getting 15% in workers' comp. Right. And then the high end is about 33 and a third, where there is a cap. Right. And maybe I saw 40% in one. So you've got all the data that there is. And so I think you do have to just kind of come up with something.
Right, and a rate and a justification.
Yeah, and that's why I tend to be at the higher end of all the examples. So we do have a lot of data, and thank you for compiling that. So I think we have data to justify, or at least follow examples of other caps that are lower than a third. But I don't think that's necessary. Again, this is a cap, so they can negotiate something different. Mm-hmm. So this is sort of like a outer limit.
Yeah, cannot exceed.
So if it cannot exceed, then maybe we should go to the third. Yeah, I saw Lee. I think you're right. I thought it was 40. I think the highest.
40% in MICRA.
Yeah.
For the first 33,000.
The other thing with MICRA to keep in mind is that there's also a statutory cap on the damages that are recoverable. So
150,000. Yeah.
Yeah, I feel like 40% doesn't pass the smell test, kind of. I'm just thinking pragmatically. We didn't vote in fee caps, which I think is the right policy outcome for me personally, but it's challenging overall. So then if you cap contingency fees, which we probably should, 40% sounds high. So that, I don't know, Frida, that's probably not analytical enough for you, but
sorry,
You got to pass the smell test.
One other thing to keep in mind is that the judgment professional representative that spoke with us, I think they get 50% on the assignment of judgments.
At least, yeah.
At least 50%.
Yeah.
Amos, are you saying that a third is used a lot? I mean, I don't know that we had numbers as so far. We just saw all the, wide gamut, but what's used the most?
Yeah, so, it's anecdotal just from my practice, but I've seen a lot of contingency fee arrangements, and a third is pretty typical. It does sometimes, if a trial is involved, go up higher. So usually there is a stepped up, and this is for attorneys, of course, but an attorney, but typically a third is acceptable and pretty standard as far as I'm aware. With some exceptions. And of course, there are lower and it can be negotiated. So this is just, and that's, I don't know that there's an official cap out there that regulates it. I think that's just industry standard, if I will. Greg, you're nodding. Does that?
Yeah, I agree. That's, I mean, in the employment context, it's usually a third prior to trial and 40% if you have to go to verdict.
So would it make sense for us to do a third then instead of a fourth, basically where we are with the 25%?
Yeah, that's what I would, I would support either, but I think my inclination is because this is a cap and it can be negotiated, to do a third as the ultimate cap and allow people to potentially negotiate something less. And a third isn't offensive to me because again, it's somewhat standardized out there. I think.
So why don't we write it up that way, and then we'll discuss it with the group.
Yeah, we have it written up with just a blank, so I'm ready to. I can even show you the rule right now, the way we left it, if that's helpful.
Is there any? I agree with the consensus. I'm just curious from the best place for addressing this. Is there any thought or discussion about whatever statutory implementation is needed for this program to have this be a law as opposed to a rule of professional conduct? Because while you can impose discipline under the standard, I wonder if clients should have some other greater legal protection in terms of the limitation. And so I don't have a suggestion here other than to say, please continue drafting as you're drafting, but maybe just hang a sign on this and to not foreclose the possibility that this could be addressed either in conjunction with a statutory change, or it might be better placed as a statutory requirement.
I think that's a good point, Andrew. Actually, I would probably, I imagine it might be addressed by statute, and then the rule would just make clear any contingent fee permitted under this rule shall not exceed the allotted amount, and then refer to the statutory provision.
That would be perfect. Yeah.
Well, we can do it as an alternative too in the rules, so that we could say if it's not in a statute, this is how it would look. But it is if it is in a statute, we would insert statutory reference here.
I do think it's a very good point, and the court rule might also be better than than rules of professional conduct, including because I think the Office of General Counsel weighed in about some concerns about setting fees and fee caps, and I assume that would apply here too, where if it's the court setting it by court rule, that might be okay. But defer. I don't know if maybe it would be the same if it's a rule of professional conduct or a court rule. But it seems like that's another possibility.
Yeah.
So I agree with everything: consumer protection, having a cap, having it be negotiable, definitely. I like that aspect of it as well. But just coming up with an actual percentage number, I'm having a difficult time with that. So I'll just read the material again and see if I can find something to help me.
One observation I wanted to make in regards to what is ultimately decided as the policy decision on the quote unquote cap as the percentage is that I think this type of restriction coexists with the overarching prohibition in 1.5 that a fee still cannot be unconscionable. And so if the cap sets the ceiling, but there's very little risk involved of non-recovery, that's really the foundation of a contingency fee arrangement, then trying to negotiate at the higher end of the cap might still run afoul of the unconscionable prohibition because it's exorbitant given the limited amount of work and almost zero risk of that collection case given its specific facts and circumstances. And so I think if you're thinking about a cap as a ceiling, but below that is still all the regulation of fees that would be exorbitant and disproportionate to services rendered, I think that helps because the cap shouldn't be taken as the default automatic charge or minimum charge. The services still have to justify it, I think.
Interesting. Can I ask you, if we have a family law paraprofessional and we're talking about enforcement of a child support judgment, to what extent does that then cross over to the private child support collector legislation? So are they governed by that, or are they governed by paraprofessional rules, or both? Anybody know?
Well, if you're trying to parallel the duties of lawyers, then lawyers who have dual occupation or multiple license, the past guidance given in case law and ethics opinions is that the lawyer is beholden to all of their professional obligations. And to the extent that the professional obligations conflict, they have to give the nod to the attorney professional obligations when representing a client or in a practice of law activity. So if you're an attorney / real estate broker, you have to comply with both. And if there is ever a conflict and it's vis-a-vis services to a client in the practice of law, you have to follow the lawyer professional obligations.
Okay, so this will just trail that, right?
I think that's the assumption, but that is really a creature of case law and discipline common law. And I don't think it's really in the attorney rules of professional conduct. So you would think that those same types of interpretive constructions of the paraprofessional duties would follow the same trajectory when those rules are litigated.
Well, hey, we're creating here. Should we add that in?
I'm trying to, Reba, can you explain again what the issue there?
So it's kind of similar to the example Randy mentioned about the lawyer being a real estate agent, right? So what I'm saying is that if a private paraprofessional who's licensed in practice of family law now wants to do the enforcement of child support judgment, okay, and to what extent do they become a private child support collector and then are under those rules, which have no caps? And these rules, we're saying enforcement of judgment, cap. So what I'm hearing Randy say is that they have to follow the more restrictive rules, or they have to follow paraprofessional rules, right? So if in the paraprofessional rule, there's a cap, just because there's no cap in the private child support collector set of rules doesn't mean that they can have no cap.
So this is not an area of law I know very well. So are you saying that non-licensed individuals can enforce child support judgments on behalf of individuals, and that those are not subject to any caps? They would
That's right.
essentially
That's the
be
setup.
acting like a judgment professional, like the person who came and spoke with us. So they're receiving an assignment. Yeah.
Right.
Okay.
So to what extent then are they bound by the rules of the paraprofessional rules, because they happen to be paraprofessional, licensed paraprofessionals?
I see.
Well, there are some things in the codes, in particular the Business and Professions Code, that license other licensees. And so private investigators or collection agencies. And it's within those licensing schemes that you would often find an explicit statement that, for example, the rules regulating a private investigator do not apply to a person who is a licensed attorney when engaged in the practice of law to avoid that conflict that you're describing, Fariba. But that, it's not throughout every licensed professional. So you don't see that with cosmetologists, but you do see it with respect to professions that might overlap with practice of law activities. But the licensing scheme for the other profession will actually say that if you're a lawyer in the practice of law, then you don't need to have a real estate license to do a closing. You can do it under your, higher license as an attorney. And that in part informs that sort of common law and ethics opinion analysis of those conflicting duty issues, to say that you're probably going to be held to the attorney standard when that happens.
The only thing I would add to that too is if you're a paraprofessional, you already have a paraprofessional client relationship with that individual, and you're essentially taking an assignment of judgment so that you can enforce it as a pro per. That would implicate Rule 1.8.1, because now you're entering into a business transaction with a client. And so that means the transaction and its terms need to be fair and reasonable. They need to be put, and the role of the paraprofessional in that transaction needs to be fully disclosed and transmitted in writing to the client. They should be told either be represented by independent counsel in that transaction or be advised to seek the advice of independent counsel and provided a reasonable opportunity to obtain that advice. And they need to provide informed written consent to the paraprofessional. So that's where Rule 1.8.1, which we spent some time on, would really be implicated at that point.
Okay.
So if they're essentially say, if we have a fee cap, this is kind of dovetails into what Randy was saying. If we have a fee cap on this type of activity and the paraprofessional is not licensed to enforce judgments, they're a family law paraprofessional, but they decide, hey, you know what I'm going to do? I'm going to just get an assignment. They're starting to essentially play a shell game with their own client and query whether or not those are fair and reasonable terms if they suddenly extract a 50% or more fee for an assignment of a judgment that they would otherwise need to get a license to perform for their client or refer them out to somebody that could do it. And there's a fee cap involved in that. I think that this might be a very difficult position to put yourself in, and I'm not sure many of them will want to do that, but essentially I think we do have some guardrails in place to protect against that.
Mm-hmm. And I think earlier we might have also kind of touched on this when we talked about the firm where there's an immigration attorney, there's a family law paraprofessional who is a co-owner, and then the attorney asked them to put on their paralegal hat and do this immigration forms, right? So what if there's a lot of crossover between immigration and family law? We see that every day. So what if the client now has a family law issue and then the paraprofessional gets involved, but this time in a business, would that be in the business relationship then, and the rules that you just talked about apply?
To the extent they're seeking an assignment of the judgment for themselves.
No, it just they're not putting on their paraprofessional, family law paraprofessional hat and not performing those services for this client who was
enforcing the child support judgment.
Enforcing or maybe even filing a divorce. I mean, they're not putting a different hat on, all these different hats, right?
Well, my understanding that the family law paraprofessional license does not include the ability to enforce a child support judgment.
Okay, I was not aware of that.
And maybe I have that wrong, but is that part of the licensure for family law paraprofessional?
I think
it might be.
I think it's included.
Oh, okay.
I'm the chair of the family law committee. I know it's included. Hello.
The right person asked. So to the extent that is, then they have to comply with this rule. I don't think they can suddenly say, you know, I'm not going to act as your family law paraprofessional for this last bit of our representation. Now I'm going to act as a judgment professional.
Right. Or a private child support.
That can be foreclosed to them. They can't, I don't think they can do that because that would not be fair and reasonable terms of the transaction under Rule 1.8.1. So.
Okay.
Yeah.
Good to know.
All right.
Okay, Kim, do you need to go?
Yeah, I'm gonna jump off. Thank you.
Thanks.
Okay, I'll update you later on where we stand on the rest of these
Perfect.
rules. Okay. Okay, so I think we can move on. Did we come, she already jumped off, but did Amos and Kim come to a consensus on 33 1/3%? And Fariba wants to think about it and revisit it next time. Okay.
I think that
I will share my screen again because there are a couple rules that we've already discussed that we need to circle back on because of some comments that we received from Professor Moore. So
I just found out I need to leave a few minutes early, just like 5 minutes before.
Okay, that's fine. All right, so Rule 113, which is organization as client. Steve Fleshman, and I'll bring this up, but first I just want to identify the issues. Steve Fleshman had a comment regarding DBAs and whether it's problematic to allow representation of an individual business owner, but not a corporation. And perhaps somebody has a better understanding of exactly what this issue is. I'm having a hard time grasping that one. And then also Professor Moore had a comment about Rule 113 regarding its applicability for paraprofessionals practicing in a firm with lawyers who represent organizations. So that to me seems like a stickier question. But first let's deal with, and I will roll to the
Can you make it bigger, Greg? Because I can't.
Yeah.
Sorry.
Hold on 1 second. Let me get to the rule and then I'll make it bigger. Okay, this is the rule. It's deleted right now because we have decided that paraprofessional, is that bigger? Can you see that?
Yeah.
Okay. So essentially, just to give some background again on this rule, this actually, especially A, is an area in which we are providing guidance somewhat to lawyers that when they are employed or retained by an organization, they need to conform the representation to the concept that the client is the organization itself that's acting through duly authorized directors, officers, employees. And then the remainder of the rule really focuses on what lawyers need to do if they reasonably believe that one of its representatives is acting in a way that's either violating the law or might likely result in a substantial injury to the organization. It's basically marching up the chain of command to alert people, especially when it's the person that may be causing a threat is somebody that they have to interface with. And reminding them of their obligation under the duty of confidentiality as well. So we removed this because the group had decided that we would create a restriction that paraprofessionals would not be permitted to represent organizations. Steve mentioned something about, is this problematic for DBAs? And I guess the reason I'm struggling with it is because a DBA is essentially, as long as it's a sole proprietor, it's an individual really, and that's the way they're viewed under the law. So I don't think that there's any restriction on representing an individual, even if they're doing business under a trade name. But if you have a different concept of that as subcommittee members, I think we should discuss that.
So I agree with that. I think that's right. I guess there might be a question. I don't know where the language of the prohibition is, but there might be some benefit to clarify it's a prohibition against representing organizations, or stated otherwise, you can only represent individuals, I think is what we intend, right? And so there might be some gray area where you have a sole proprietorship, which is a business, as well as an individual, or there might be some confusion. But I think the idea is, at least we decided, I think, that we want to prohibit representing organizations, and paraprofessionals can only represent individual persons.
And I think it will be set forth under the rules of court that define the scope of licensure. That I think that's probably the appropriate place to say that they're limited to representing natural persons, which would include somebody who's a sole proprietor that might be doing business under a trade name or business name.
Correct.
Yeah.
Has this become an issue since we allow for ownership, joint ownership, and the attorney may be representing?
Well, that's the second issue that Professor Moore
Right.
brought up, and that really pertains more closely to Rule 113. I think Steve's comment was just more general in terms of that restriction, but that could be problematic. So, because we can imagine a scenario in which paraprofessionals are either employed by a law firm or they have a minority stake in a law firm, and they are brought into a matter where they can provide legal services within the scope of their licensure to the lawyer's client, but the lawyer's client is an organization. Could be a nonprofit organization, could be a small, LLC that operates a restaurant, something like that. They essentially would be prohibited from doing that under our rules. And it's just another wrinkle that we should consider, because to the extent that we would permit them to provide that kind of representation or consider them to be a representative of the lawyers of the organization, then you might want to have a rule like this in place, because this is intended to protect the public, protect the, especially if there's an organization out there whose constituents are engaging in bad behavior, and they have ethical obligations to alert those that can avoid the danger and risk of harm, not only the organization, but to others.
Considering the areas of law that we're allowing licensure, in which one do you think that scenario would come up?
Housing, it could on the landlord side, but that's not the type of landlord.
But that would be are we allowing for commercial?
Yeah, and I think they're excluded. I can't remember exactly what the resolution is, but I know that it's not the type of landlord we're interested in serving with the program. And then I'm thinking about the enforcement of judgment, because right now, no representation of collections agencies, but just I don't know, a small business that had a judgment to enforce. That's the kind of thing I'm thinking. Where
There could also be a tenant, but we're not allowing for any kind of commercial work to be done in the housing. So I'm just having a little bit of a hard time, again, thinking about maybe we're creating a problem where a problem doesn't exist.
Well, I think probably the better way of viewing this is this may be an area where we do need a comment. And this is going to come up also, I think, in the next rule as well, where we have lawyers and paraprofessionals practicing together. They need to know that paraprofessional can't work on any matter that comes through the door, even if it's within their area of expertise and the licensure, because it may be an enforcement of judgment matter. It's within the jurisdictional limits that we've set up, and they want to hand it off to that paraprofessional, but it's actually a corporate. This person's an LLC, and sometimes, especially with if we're allowing them to represent a small landlord, they may not know immediately that actually they're representing an LLC and not an individual. So I'm not suggesting that we need to change this rule or revisit this, but I want to alert you, because this and it's going to come up in the next rule as well. This may be a area where we really do need to have a comment so that everyone knows, especially in this, trying to decide where the comment goes is another not easy lift, but maybe it's probably 5.4 and or 5.5.
Yeah, I agree. And I don't think the answer is to put back a version of this rule. So it sounds like everyone is in agreement with that we should stick with the prohibition on representing organizations and just make sure that is clear and part of training and maybe a comment. I agree.
Okay. So in the same vein, so we can move on to 115, because this is similar. Here's Professor Moore's comment. Regardless of whether, so just a reminder, this is the rule that has to do with safekeeping of the funds and property of clients and third persons, because sometimes law firms come in possession of third person property and they need to comply with this rule. B was a carve out, especially for criminal defense attorneys, bankruptcy attorneys, who alerted the Rules Revision Commission that this is problematic, that sometimes it's not in the client's best interest for them to place their property or funds into the client trust account. And that because of potential seizure or forfeiture. So we have a carve out that a flat fee paid in advance for legal services may be deposited in a lawyer's or a law firm's operating account, provided they meet these requirements that disclose in writing, and it doesn't, the flat fee exceeds $1,000. And we decided, well, this is probably not necessary because paraprofessionals, one, are not doing criminal defense work or bankruptcy work. There just isn't the same public policy considerations that we need to worry about. I don't know if we need to change anything here, but Professor Moore said, in response, regardless of whether paraprofessional can deposit a flat fee in their operating account, need to clarify that a firm consisting of lawyers and paraprofessionals are still able to do so. Otherwise, a lack of a provision corresponding with the lawyer rule will create much confusion. And I think that's actually a good catch on his part. Again, I think this is an area, clearly the comment would go here, and the comment would essentially say, explain what the lawyer provision provides and perhaps some explanation as to why, and that this rule does not prevent lawyers who are practicing in the same firm with paraprofessionals to place flat fees within their operating account as long as they're in compliance with Rule 1.15. If that makes sense to you.
Comment is good.
I'm confused as why the comment would go here and not to the lawyer rule.
Well, I probably should go in the lawyer rule as well.
Yeah, okay. Because paraprofessionals, I don't think it's a concern to the paraprofessionals who aren't doing that practice. So it would more be a comment to the lawyer rule to make sure they know they can still follow the lawyer rule.
Yeah, this may be a belt and suspenders thing, just to make sure that we have cross references in both places, because there may be instances in which paraprofessionals are, they are responsible probably for managing the client trust account as well. And so if they're going to their rules, they may not have the guidance that
Right.
be provided in the lawyer rule. Okay. All right. Well, we have 20 minutes left, and we actually went through our work plan for today.
Yay!
Oh, I'm sorry. Close. We did have one more. I added one more in because I was optimistic about getting through 5.4 and that bore itself out. So rule 3.3, candor to a tribunal. I think this one really comes from me, and it's a very discrete issue, but I think it's actually something we need to revisit, given that the general rule is to allow for full court representation. So this is similar to the lawyer rule. They have you can't make a knowingly false statement to the tribunal, fail to disclose legal authority. And then if you come down to this last provision D, in an ex parte proceeding where notice to the opposing party in a proceeding is not required or given, and the opposing party is not present, a lawyer shall inform the tribunal of all material facts known to the lawyer that will enable the tribunal to make an informed decision whether or not the facts are adverse to the position of the client. So this is a protection for towards the administration of justice, to make sure that the decision maker has all the facts necessary to make a just decision. And so it imposes an ethical obligation on lawyers to disclose everything, not just the stuff that's good. And we didn't have this here originally because, which was captured in my comment, the provision is only needed if paraprofessionals are permitted to advocate before a tribunal in an ex parte proceeding. Professor Moore also said, consider a paraprofessional who's also a licensed patent agent. There's another one of those hat switching situations, which I think is a good point. Another reason why we might want to rule 5.7 here as well. But
Can you?
I'm just wondering whether or not we need to actually include this provision, because now I do contemplate that there may be situations in which the paraprofessional is the only person in the courtroom representing a client. And to the extent that it occurs, they do need to you know, disclose this information to the tribunal so that it can make a just decision.
I do think the subcommittees have contemplated representation in ex parte proceedings. So that being the case, I think we should have the parallel rule.
Mm-hmm.
I
Can
agree.
you explain the patent agent thing? I don't understand the relevance.
Well, I think you don't need to be a lawyer to be a licensed patent agent. And to the extent a paraprofessional is going to offer that as another service, whether or not they should have this. And I think Kevin was also reacting to the comment that I had made that we would only need this if they were allowed to advocate in a tribunal.
Oh, okay.
Yeah. So, but, and so I'm sure putting this in actually addresses his comment fully. I think this is, again, one of those situations in which we would expect paraprofessionals to abide by their ethical obligations when they appear before a tribunal, regardless of whether or not they're acting as a paraprofessional in that instance, or providing law-related services, which I would probably qualify this as. But Randy, do you have any comments on that?
So Professor Moore used to do, I guess, patent work earlier in his career, and I think he knows that there's something analogous in that type of activity to the objective rationale for this rule. And so when you're prosecuting a patent application, I think one of the requirements is to disclose, quote unquote, prior art, so to speak. And if you make that disclosure, it's usually against the interests of your client, because it might suggest that the patent you're pursuing is subject to that prior art. And so I guess there's an analogy between that type of protect the administration of the patent appeals board's activities, in the same way that when you're in an ex parte setting, you might have to act against the interests of your client to disclose everything that the decision maker needs to make in order to come to a just result. But like you say, Greg, it might suggest that something like 5.7 is needed for paraprofessionals if they're going to be engaging in things that are related but are non-paraprofessional services.
Mm-hmm. And just so the group knows, and maybe this is something we could, I know we have a chock full agenda for next time, but in terms of understanding 5.7 a bit more, the Rules Revision Commission did not recommend that California adopt a version of ABA Model Rule 5.7 when they sent the rules to the court. The Closing the Justice Gap group, as part of their charter, is going to reconsider that decision by the Rules Revision Commission.
Yes.
And I think we now are seeing at least a couple examples just today in which there may be a need to have a similar rule or a version of that rule for paraprofessionals, to the extent that we imagine that they're going to be setting up shop to do things other than licensed paraprofessional work. So what we can do is I can send around a version of the ABA model rule. I can also send you a link, because the ABA is very good about putting together these charts about how each rule is implemented in every jurisdiction. So you can see how different jurisdictions have implemented as well. I think there is a version in the Washington rules for triple LTs as well.
I'll just say, I think it would be worthwhile, because I do contemplate licensed paraprofessionals wearing multiple hats, doing potentially other services that are not legal services, and at least allowing for and contemplating that flexibility.
Yeah, especially thinking about the eligible licensees, including explicitly we're going after paralegals and LDAs, for example.
Can you see what I just brought up from the Washington set of rules?
I can't, no.
Yes.
You can?
Your eyes
Yeah,
are better than mine, Farida.
Yes,
Right.
you
I
can
see, 'cause
expand it on the screen.
How about now?
Yeah, it's great.
Okay, so this is their version of that ABA model rule. That LT is subject to the rules of professional conduct with respect to provision of law-related services as defined in paragraph B, if the law-related services are provided, one, by a triple LT in circumstances that are not distinct from the triple LT's provision of legal services to a client. So when it's difficult for a client to understand, are they wearing the triple LT hat now, or are they wearing the, some other hat, then they need to comply, obviously, or in other circumstances by an entity controlled by a triple LT individually or with others, if the triple LT fails to take reasonable measures to ensure that a person obtaining the law-related services knows that the services are not legal services and the protections of the client triple LT relationship do not exist. Okay.
Oh.
Yeah. So if you either it's hard for a reasonable person to discern the difference between the services, or you haven't taken the steps to really try to explain that to your client in any way. And then B defines what law-related services are. Services that might reasonably be performed in conjunction with or in substance are related to the provision of legal services and that are not prohibited as unauthorized practice of law when provided by anyone except a triple LT or a lawyer.
So I like a version of this. I think it could be very useful. Again, I would go maybe one step further because this does not contemplate acting as a paralegal under the supervision of an attorney, because those would be legal services. And it seems like that, in my mind, that's parallel. So when they're no longer wearing their licensed paraprofessional hat, acting outside the scope of that license, whether they're providing legal service, whether they're acting as a subordinate to a lawyer providing legal services or acting in a non-lawyer, non-legal services capacity, I think similar issues arise. It should be clear to the client.
Yeah. Well, I mean, that's a good point. I get whether legal services implies the practice of law or not. I'm not sure whether that's clear or not. They certainly wouldn't. Let's see, prohibited as the unauthorized practice of law when provided by anyone except a triple LT or lawyer. They're not prohibited. Okay. I'm not sure that doesn't capture the paralegal services.
I'll have to look at it carefully, but I read this, especially when it defines law-related services related to the provision of legal services. That seems to exclude legal services itself.
Mm-hmm.
But I can read it carefully. It's at least not clear.
Yeah, we'll do a little bit of work on this too. And maybe we can take this up next time.
So what if the protections offered for the other service, the law-related services, they're putting on another hat, is they're more restrictive and more protective of the consumer? If I'm remembering correctly, our conversation earlier from with Randy, that right now attorneys are supposed to follow either the more restrictive rule or attorney rules. And here the triple LTs are supposed to follow triple LT RPCs, and has nothing to do with less restrictive or more restrictive. And again, I go back to my example. Sorry, I'm just going to go back to my example of enforcing a child support judgment. The private child support collector legislation, some parts of it are way more restrictive than anything we've made available here. And I'm just wondering, from a consumer protection standpoint, would it be better to just say you have to follow them both, almost? And as long as they're not inconsistent. And if they are inconsistent, you're following them more restrictive. Just putting it out there for discussion.
I think you've pointed out something important, because it's one of the main reasons why we've never had a version of 5.7 in California, is because we do have a pattern of case law and other authorities that many, when they evaluate the terms of the model rule, do not find to be as client protective as the discipline common law and the other authorities that we have on the topic. But the rebuttal to that is that lawyers don't know all that case law. A lot of it is very fact bound. So couldn't you improve the compliance by having an actual rule on the topic, even if that rule is different from the model rule and is more complicated by having to codify the existing law? And the last RRC, Rules Revision Commission, actually took a shot at that, as well as the ADLs looking at it, still couldn't get consensus. So that's why, as Greg mentioned, it's been carried forward to the Closing the Justice Gap Working Group to take a hard look at. But I think, Fariba, you mentioned earlier that we're writing on a clean slate. So however we wanted to promulgate what should be the standards under the California Paraprofessional version of 5.7, I think you have a little bit more flexibility without, again, the baggage that the lawyer regulation has.
Mm-hmm.
It might help if we are going to look at this, not to take up too much time on it, but hear a little bit more about what was proposed by ADLs or the prior Rules Revision Commission, because they probably thought long and hard about it. So to take up where they left off as opposed to starting fresh.
Okay.
We can share the version that came out of ADLs.
So we're going to add that for next week
Well,
because we're going to get.
let's
through
see what we
our-
got for next week. So I'm
Do
gonna
we have a
pull-
6-hour meeting next week?
Well, if we can knock out that informed consent and written agreement set of rules quickly, then we'll have a luxurious
Plenty
amount.
of time.
What do we have? So this is what I have. These dates are completely wrong. That's June. June 11th. We have the informed consent and written agreement rules. This rule has to do with employing disbarred or suspended attorneys. And there's a whole rule around this, and we can give you a rundown of what the rationale for that rule is. But I think we need to deal with it in some way because, especially because we're going to have firms that are going to combine lawyers and non-lawyers. So there may be some employment of disbarred or suspended attorneys, at least to the extent that the lawyers in the law firm believe it's permitted under their set of rules, but also consider whether or not we would want that to be another avenue. And usually this is a rule that protects the public, but also provides these disbarred, suspended attorneys, involuntarily inactive attorneys to rehabilitate and potentially return to the practice of law in some way. So we can talk about that. And then 3.6 is the trial publicity rule. Steve Fleshman had mentioned this in the last meeting, to the extent that we're going to allow full court representation in family law matters. You're going to have some very highly publicized divorce cases probably that potentially could involve a paraprofessional, and that, we would want to have these ethical restrictions in place for paraprofessionals as well. So revisit that. And then Rule 1.8.10 is the prohibition on sex with clients. One thing about this rule is that this behavior is regulated both in the State Bar Act and in our Rules of Professional Conduct. The State Bar Act has some additional provisions that it may be important to make sure it applies to paraprofessionals as well, in the absence of any statutory intervention here. But this may be another area where the legislature essentially decides to extend the restrictions on lawyers to paraprofessionals as well. But we should at least incorporate this into our rules so we're not neglecting it. And then 3.7, if we wanted to discuss that. So we do have.
I got to jump off.
Okay, bye, Amos.
Okay.
The other thing that we have to
Thank you,
do
Amos.
is to hear from OGC, get an update on their work, reviewing all the other statutes and non-RPCs they've identified. I'd say a small number of true policy issues that need to be considered. That is slated to go to the full working group on the 25th, that being the policy questions, but they need to come to this group first. So I do think we're going to have to schedule another meeting after June 11th and before the 25th. And I don't think we have one now. So look for
No,
that.
the next Fridays is the last meeting that's scheduled at the moment.
Linda, I just sent you an email. Didn't the working group decide to exclude disbarred attorneys?
Yes.
I don't know, Greg, if that changes the conversation. But
I think that excludes disbarred attorneys from being licensed. I don't think that addresses
that
the
doesn't-
issue of hiring someone.
Yeah.
yeah,
Employing
okay.
This rule has to do with if you want to hire somebody who used to be an attorney who's been disbarred, you have to alert the state bar, you have to alert your clients, obtain informed consent to let them know, hey, I'm going to have a disbarred attorney work on this,
Okay.
and provide information of how they're going to protect information. There's a whole bunch of safeguards that you need to follow, but it becomes more complicated now that we have decided that firms that are comprised of lawyers and paraprofessionals are working together, because it opens the question, at least.
Okay.
I'm not sure if this belongs here or even if it's an issue, but should the enforcement of judgments be a specialty rather than just be included in family law and the other areas of law that we're working on?
Well, enforcement of judgment is coming back to the work group, not in June, but it'll be in July.
Okay.
You could raise that then. Right now, it's part of general civil.
Yeah, it's not part of regulation.
Yes, separated by case status. In family law, we have enforcement of judgment and so on, but I'm just wondering.
Okay.
Okay.
All right.
Thank you.
Great meeting. Thank you, everybody.
Okay.
Yeah.
Bye-bye.
Bye-bye.